You brought a lawsuit against your doctor claiming that he was careless, causing you significant harm and injury. Your case goes all the way to trial. If your attorney goes ahead during closing arguments and now uses a trial exhibit that was not allowed to be introduced into evidence during his closing arguments, what can happen to your case? What can happen to the attorney for him trying to use something that was not allowed to be shown to the jury? You want to know the answer? Come join me for a moment as I share with you some great information. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. All right, so you brought a lawsuit against your doctor claiming that he was careless and that his carelessness was a cause of your injury. You have a medical expert, a board-certified medical expert who reviewed all your records and confirms that yes, your doctor violated the basic standards of medical care, and yes, that was a cause of your injury. It doesn't have to be the cause, it only has to be a cause. And yes, your injuries are significant and permanent. Great. So now you go ahead and prosecute your lawsuit. The defense turns around and says, hey, why are you suing me? We did nothing wrong here. We treated you appropriately. And then they say, you know what? If we did something wrong, so did you, Mr. Patient. And then they turn around and say, you know what? If I did something wrong, whatever I did didn't cause or contribute to your injuries. And then they say, you know what? If we did something wrong and they caused you injury, your injuries really are not as bad as you claim them to be. So that like sticks it in the back. So what happens next? So now your case goes all the way to trial because they refuse to negotiate. They refuse to try and settle this case, which means your case is going the distance. You're going all the way to trial. So now in New York, it takes 2 to 3 years for your case to actually get to trial. Now, let's say you're on trial for 2 entire weeks. And now during that trial, you are on an emotional roller coaster. You're on emotional highs and then emotional lows, depending upon who's questioning the witness, how the cross-examination is going, and how your witnesses are doing. Are they believable? Are they not? And you can feel the tension going on in the courtroom during the entire time. But now, here's something interesting. Your attorney has tried to get certain information into evidence. He's tried to get certain documents that he feels are very important into evidence. In fact, he's blown up certain medical records, put them on big poster boards, 30-inch by 40 inches, to show to the jury the enlargements, to show to the jury exactly what was done wrong. You know what the defense attorney does? Objection, Judge. That's improper. And the judge turns around and says, objection sustained, meaning that the lawyer is correct. This should not be addressed. This should not be admitted into evidence, which means your attorney now has a problem. He can no longer refer to that particular document. He can't hand that document to the jury for them to look at. He cannot base his conclusions upon that particular document because it's not in evidence. So your attorney has to try and come up with other ways to try and get that document into evidence. If he's unsuccessful and cannot get that into evidence, now, can he use that at the time of closing arguments? Can he use that to show to the jury that he has a valid case on behalf of you, the injured victim, the injured client? The answer is no, he can't. Why not? Because the only time you can ask a jury to reach a conclusion in your favor is based upon the evidence that they've heard, based upon the admissible evidence, I should say, the evidence that has been presented to them that the court has allowed them to see, to hear, to view. Just because a witness may talk about a particular record, just because a medical expert may talk about something that he saw or heard or read about, does not automatically mean that it is admissible. So let's say your attorney is questioning your medical expert on the witness stand, and now he's asking him questions about his medical opinions. And the defense lawyer jumps up out of his seat and makes an objection, say, Judge, that's an improper question, or that's an improper line of questioning. If the judge agrees with the defense attorney, guess what? Your attorney can no longer get that information into evidence, so he tries to ask him a series of other questions to try and get that information in. If he's unsuccessful, now he's got a problem. He's got a gaping hole that he may not be able to go ahead and put all of his necessary evidence in to support your actual claim. And that could be a significant problem. So what happens then? Well, at the very end of the trial, the attorneys make closing arguments. The defense lawyer actually goes first. He makes closing arguments first. Then your attorney, the plaintiff's attorney, makes closing arguments last. Your attorney gets the last word in. Actually, that's not true. The judge is the one who gets the last word in after the lawyers have made closing arguments. But in terms of the sequence of what the jury hears, The defense lawyer goes first, then your attorney goes after. So now, your attorney during the course of closing arguments picks up that exhibit, that big enlargement that he was trying to get into evidence. And now he says, ladies and gentlemen, look at this document. Look at what it says here. And now the defense attorney jumps up out of his seat and says, Judge, I object. You told him that he could not use that. That is not in evidence. And you know what the judge does? Counselor, you're absolutely right. Objection sustained. And if your attorney tries to repeatedly use this document to show to the jury and explain to them that you are right and the judge and the defense lawyer is wrong, in all likelihood, the judge is going to start yelling at your own attorney. He's going to castigate your attorney. He's going to get upset. Counselor, I told you not to do that. Counselor, you were warned. Don't do it again. And now the judge is getting angry. And if your attorney continues to try and use documents that were not introduced in evidence during his closing arguments, now the judge not only will get angry, but he could in fact sanction and fine your lawyer for what he's doing. Because clearly your lawyer is trying to inflame the jury. He's trying to convince them with documents and evidence that has not been put before them. And that could sway their opinion. And so, what can ultimately happen? At the very end of the trial, after the jury comes back with a verdict in your favor, the first thing the defense attorney will do is he's going to jump up out of his seat, say, Your Honor, I ask you to dismiss this verdict as being against the weight of the evidence, as being inconsistent, as the defense attorney now may have a legal right to overturn that jury verdict. And if the judge says, you know what, I'm going to let the jury verdict stand, well, what that really means is that your attorney has bought an appeal. And what does that mean? It means that now he's going to appeal the case. And he's going to have a series of appellate court judges go ahead and evaluate the record, exactly what was done during the course of the trial. And if they feel that the jury was somehow influenced by the argument that he made during the course of closing remarks, guess what? Now the appellate court, the higher court, has the ability to throw out that verdict and say, you know what? You did something wrong, counselor. We're going to fine you or sanction you, or we're going to throw out that verdict and now send you back for a new trial to start all over again. And now if they send you back for a new trial, you've got to try that case all over again. You've got to bring in all the medical experts, get all the witnesses back. Now you've got to spend the entire length of time going through the trial and dealing with the uncertainties of what can occur during a trial, as well as the emotional highs and lows that happen during each and every trial. So let's go back to the title that I raised at the beginning of this video. What happens if your attorney tries to use documents and models and exhibits that have not been introduced into evidence at the time of closing remarks, and he tries to use those to influence the jury? Now you have a clear understanding of what could happen in that scenario. You know, I realize you're watching this video because you likely have questions or concerns about your own matter. Well, if your matter did happen here in New York, and you're thinking about bringing a lawsuit, but haven't done so yet because you still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know I answer questions like yours every single day, and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. Well, that's it for today's video. I'm Gerry Oginski. Have a wonderful day.